Well, things are happening on Capitol Hill. Democrats are considering the so-called slaughter solution to get the Senate's health care bill through the House. The move would allow House members to approve of the Senate bill without actually voting on it, which is why Speaker Pelosi says she likes the maneuver. But is it constitutional? Michael McConnell is a professor and director of constitutional law at Stanford Law School. Until this past summer, he was also a judge on the prestigious 10th Circuit Court of Appeals and was reportedly on President Bush's shortlist for the U.S. Supreme Court. Judge McConnell, thanks so much for being here on America Live.
Thank you, Megan.
All right, so you came out with a very interesting op-ed in the Wall Street Journal saying you do not believe that this is constitutional. Why?
Well, that's right, because the Constitution, Article 1, Section 7, lays out a procedure by which legislation has to be passed, and it requires that both houses of Congress, the Senate and the House, separately pass any piece of legislation before it goes to the President for his signature. And along the way, Article 1, Section 5 then further specifies that upon the demand of 1/5 of the members of the House or Senate, that the yeas and nays will be recorded on the journal. The purpose of these provisions is to make sure that when our representatives are voting on the people's business, that they do so on the record, and that their constituents can find out exactly what they've done.
And the thought is that there would be
pass
accountability
legislation
behind the vote.
without actually doing it is an obvious way to try to evade these provisions.
But Judge, the response that we heard yesterday, including from Louise Slaughter's office, was that we've been doing it for a long time. Started back in 1933. The Republicans do it. We do it. To now come out with claims that it may be unconstitutional doesn't pass the smell test. How do you respond to that?
Now, what they have, I am not an expert on the House rules and the entire history here, but I did read through the list that the Speaker's office put forth of when this rule, this sort of what they call a self-executing rule, has been used before. And almost all of those are a quite different situation, where they use the rule in order to amend a bill that is pending before the House, thus avoiding any individual vote on the amendment itself. But the bill is then actually voted upon by the entire body when it comes to the floor. This is an entirely different proposition than that. So to claim the precedent for the use of the rule for one thing and then using it for a dramatically different thing is just not very persuasive.
There is no U.S. Supreme Court precedent directly on point, but there are a couple of cases that seem to suggest what? That this is unconstitutional, or that it may be constitutional?
Well, no one could say that it's certain how the Supreme Court would rule on this. There are too many uncertainties. In fact, we don't even know exactly what procedure the Rules Committee might vote out, or if they do. We citizens can only operate on the basis of the rather vague descriptions that the Democratic leadership has provided to the press. So, you know, I certainly wouldn't want to make a confident prediction, but the Supreme Court has been quite insistent that in order to comply with Article 1, Section 7, the exact same text of a bill has to be passed by both the Senate and the House of Representatives. Now, as I understand this procedure, the idea is that the House would take the Senate version of the bill and not without actually voting on it, deem it to be passed by virtue of a vote which would be adopting separate legislation which amends the bill in order to eliminate all those special deals and so forth. And they would then send the original Senate version to the President for signature, while sending the amended, the new bill amending that legislation to the Senate. Well, I don't think that that complies with Article 1. Just think about it this way. If they did that in the straightforward way, that is, passing a single bill which both adopted the Senate version and then amended it, they could neither send it to the President, because the Senate had not passed that identical bill, nor would it be eligible to go back to the Senate for reconciliation procedures, because it wouldn't be amending enacted law.
Judge, I have two questions I want to get in, because we're running out of time. And number one is, do you think that we are about to see, if they pass this in the House, or they don't pass it, but they deem it passed, a legal battle, a protracted legal battle?
Well, I do think the majority is introducing an unnecessary risk by going this way. No one knows what the result of that would be, but it's certainly not impossible. It's, you know, a reasonable possibility that they would do all of this only to find that the courts strike it down, not on its substance, but simply for its failure to comply with the bare bones requirements of procedure set forth in the Constitution.
And my other question to you, sir, is, you know, do you have any political beef here? Do you have it in for Barack Obama? Do you have an axe to grind with him? Do you have any history with him?
Well, actually, my only history with him, I have met him. My history with him is that I assisted in recruiting him to the University of Chicago Law School after he graduated from Harvard Law School, and I want the president to succeed, but I think the best way for him to succeed and for any majority, whether it's Republican or Democrat, to operate in the Congress is to comply with the rules of the Constitution, to do things straightforwardly so that the American people know what their representatives are voting for.
Judge Michael McConnell, thank you so much for being here. We appreciate it, sir.
Thank you very much, Megan.
All the best to you.